Reasons why an individual would be charged with a domestic violence charge would be the relationship or the living situation of you to that particular person. For example, husband lived with wife, or girlfriend lived with boyfriend 2 years ago, and now they share a child. They no longer live together, but they got into an altercation, and now the husband is being charged with a battery domestic violence charge. And why that is because the relationship of those individuals is such that now they share a child, and so it's considered domestic violence. It does not have to be a girlfriend-boyfriend situation. It could be a roommate, for example, because you live in the same dwelling. And so you get into an argument or an altercation, a fight, and now one of you is being charged with a domestic violence battery charge or disorderly conduct simply because of the nature of your relationship. It's important to know that domestic violence, that particular enhancer, basically what it does is it enhances the penalties to your criminal charge. A regular battery charge carries with it, depending, let's say it's a misdemeanor, carries with it 9 months jail, $10,000 fine, or both. Now, a battery misdemeanor with a domestic violence charge or enhancer adds to it a $100 fine and the lifetime ban of a firearms, the ability to possess a firearm. So it's pretty significant in terms of collateral consequences or the penalties. That's a good question, and that happens quite often where the victim says, I no longer want to charge this individual with the domestic violence charge, or I'm changing my story. It didn't happen that way. Again, this is very similar to even just a normal battery charge in that the state is the one who makes the ultimate decision. If they believe that they can still pursue the charges against you, even without the cooperation of a victim, it is their duty to protect society and determine whether or not they can still prove those charges. And depending on the situation, they may end up dropping the charges, or they may end up taking their chances, and if you wanted a jury trial, to see if the victim shows up. So ultimately, the answer is it's not up to the victim, nor is it up to the individual that's being charged. The state makes the decision. So depending on the particular case, if the victim doesn't show up at trial and the state feels that they cannot prove their case without the victim, then your case could be dismissed. However, if the state believes that they can still prove your case without the victim being there, then they could continue to go to trial and say that they believe that they are able to prove the case, and you and your attorney would then have to be prepared to still try the case even if the victim doesn't show up. So one of the most common defenses for a domestic violence charge is he said, she said, right? So she said that I hit her. However, she doesn't have any injuries on her, and there are no other pieces of evidence that will show that she had any injuries. So that what it really comes down to is credibility. And in a particular defense like that, your attorney then can help walk you through preparing yourself for a jury trial to explain what it means to whether or not you should testify at a trial, and if you testify, what credibility means in terms of your chances to win the trial, as well as the credibility of the person making the allegations. So if there are certain reasons that this individual has had, or motivations that they have had in order to make false allegations against you, then those are strategies that your attorney can help explore with you as well. having an attorney walk you through a domestic violence charge is extremely important in order to help you understand the defenses that you have and whether or not you have a good chance of winning at trial. They can also tell you the positives of your case and then tell you the negatives so that you can make the best informed legal decision as to what you want to do with your case.
Awesome.